Hi, it is 5 o'clock on Tuesday, April 3rd, and we welcome you to the 25-minute guide to Florida charging order protection, how to use it, how to lose it. This is Alan Gassman of Gassman Law Associates, and I'm here with my partners, Denicolo and Ken Crotty. And Ken and Chris have done a lot of work, not only on this presentation, but also on actually helping to change this law, because when the Florida Supreme Court came out with their opinion, their questionable opinion in this area, we did a lot of reading, a lot of writing, wrote an article. In fact, our article was quoted in the legislative report for the repair statute. So I'm real thankful for Chris and Ken for all the work that they did at that time. And we're thankful to you for tuning in here and for sending us any questions or comments that you might have. Now, we have some upcoming webinars that you can read about here. In fact, tomorrow for Bloomberg B&A, we're talking about hiring and terminating employees, what to do and what to avoid. If you can't attend that, but you would like the materials at no cost, let us know. Then we're going to talk about the Florida Guide to Prescription Controlled Substance and Pain Medicine Laws April 10th and much more. On our website, we have free webinars that you can watch as shown here. And now, page 4. What is a charging order? Chris, do you want to go ahead and take over here?
I'd love to, Alan. Thank you very much. And as on the first slide here, we have what is a charging order. And we find that it's very helpful to often start at the foundation in order to really get into some more of the nuances of charging order law. And essentially what a charging order is, it's a remedy that a creditor can get with respect to a debtor's limited partnership or LLC member interest. Now, I want to make a distinction between creditors of the actual entity, which are often called inside creditors, and creditors of the owners of the entity, which are often called outside creditors. So, for example, if I own a piece of real property under a limited liability company, and Ken and I each own the limited liability company 50% each, if there's a creditor with respect to the real estate under the LLC, that would be called an inside creditor. But if I were to get into a car accident and I had a creditor that was pursuing me in my individual capacity, that would be an outside creditor. Now, for the purposes of this presentation today, we're focused on outside creditors. And charging orders are essentially remedies that an outside creditor can get with respect to the membership or partnership interest that limits them to only what distributions come out of the entity. So the charging order is good from a debtor standpoint in that it prevents a creditor from reaching the assets of the LLC or limited partnership. It prevents the creditor from being able to manage the LLC or limited partnership. And it essentially places, I guess, a restriction on what the creditor can receive, which can be manipulated by the management of the entity, by the general partners or the managers. And because of that, some outside creditors are more apt to settle for less than what their claim is worth. And that's one of the tenets of asset protection planning, is that, we try to structure our clients' assets in manners so that it can be protected to the extent allowed by law, or protected sufficient enough to make it difficult for a creditor to reach the assets. So a charging order is a remedy for the creditor, but from a debtor's perspective, it's very helpful in that it's very restrictive. Now, looking at the slide here, slide number 4, most states have laws providing that a charging order is the sole and exclusive remedy that an outside creditor can receive. Now, as I indicated, the charging order just allows the creditor to receive any distributions from the entity out to the creditor. It does not allow the creditor to force distributions to come out, but only to intercept anything that comes out. Now, there's many nuances and many different little details that we're going to cover in this presentation today, but I wanted to just cover this basic point here so we're all of the understanding as to what exactly a charging order is. Okay, on the next slide here, slide number 5, we talk about limited liability companies, and Alan indicated that a lot has been made with respect to Florida limited liability companies and charging orders. And what I have here is the new statute, 608.433, the relevant subsections, and those are 4, 5, 6, 7, and 8. Now, this is the statute as it currently exists after the legislature changed it in 2011, and we'll get to the details of that in a minute here, but I just want to point out that this is a language you're going to find in many charging order statutes in many states across the country here. And if you look through it here, it essentially, in our statutory language, just describes what I've explained on how a charging order is a remedy that a creditor can receive to intercept distributions from the entity. One thing I want to point out here is that in Florida, a charging order is the sole and exclusive remedy by which a creditor can reach an LLC or any part of the LLC or limited partnership. Now, this is only for multiple member LLCs, and we'll talk about that here in a minute. And on the next slide, you'll see here that there's a carve-out under paragraph 6, that if there's a single member LLC, you're not going to get this charging order protection. And this is primarily what the Olmstead case was based on, and we'll get to that here in a minute, but it's just something I wanted to bring up here just to show you that there's a pretty big distinction between multiple member LLCs and single member LLCs. Now we go on to the next slide here, kind of reinforce this idea of sole and exclusive remedy. And in Florida, there's language in the limited partnership statute and in the LLC statute which essentially say that a charging order is the sole and exclusive remedy that a creditor can receive in a multi-member LLC or in a limited partnership. And this wasn't always the case here. It's essentially in place to protect the non-debtor partners and the non-debtor members of the entity from a creditor jumping in and having to, the creditor being able to manage the assets or to otherwise access the assets. Now, Ken, do you have any thoughts on this?
Well, as you said, the sole and exclusive remedy, that's not always the case in every state. We're lucky that it is the case here in Florida, because what it does is it limits the debtor's ability, or the creditor's ability, rather, to receive any other assets from the debtor or to interfere in any way with the management and the assets of the LLC. It doesn't allow the creditor to mortgage it or try and request a mortgage or any other remedy for the LLC. It just allows the creditor to receive the distributions coming out from the LLC. And the benefit of this is that it allows the management of the LLC to continue and run the LLC the way that they otherwise would, and it doesn't have any impact on the other members of the LLC. All right, now turning to Florida LLCs in particular, most commentators had thought that the charging order protection for LLCs was going to be the same as the charging order protection that's afforded to Florida limited partnerships. There was a slight difference in that the Florida LLCs got their charging order protection under case law as opposed to the clear statutory law for partnerships. But most people didn't think that there really was going to be too much of a difference. This basically all changed during the Olmstead case. And Chris, do you want to tell us a little bit more about Olmstead?
Sure. And Olmstead was a long-awaited opinion that was handed down by the Florida Supreme Court in June of 2010. And just the basic facts of this case were this gentleman by the name of Sean Olmstead and his wife each operated advanced fee credit card scams and were sued by the Federal Trade Commission for unfair and deceptive trade practices. Now, the FTC received the judgment against Mr. Olmstead and his wife, and they also got an order compelling them to surrender all right, title, and interest in their single-member LLCs, in their LLCs, most of which were single-member LLCs, turn the right, title, and interest over to the creditors. And the Olmstead says, well, wait a minute, we have charging order protection because these are limited liability companies, and because of this statute, you can only receive a charging order. Well, the Supreme Court wasn't convinced by that argument. The case went up to the 11th Circuit. It was recertified back to the Florida Supreme Court, and the Supreme Court compelled the debtors to surrender all right, title, and interest in their single-member LLCs. Now, that was the conclusion many commentators expected. We all thought single-member LLCs would not be protected because, really, the idea that there's no other members to protect here. That's what a charging order is. That's the policy grounds for a charging order. Now, with this opinion, there's language that seemed to indicate that a multiple-member LLC wouldn't be protected at all in Florida. And there was a big uproar about this, and we wrote a couple of articles about this in that time period, and we took some pretty bold stances on the Supreme Court, and for lack of a better word, kind of bashed them for their stance here, and it seems like the legislature agreed with us on this, because in 2011 there was a patch issued by the legislature retroactively which clarified the law. And this patch amendment amended Florida Statute Section 608.433 to read as I showed you earlier. And this essentially provides now that a charging order is the sole and exclusive remedy by which a judgment creditor could proceed or reach a member's interest. And that was specifically shown as the sole and exclusive remedy. The statute also explicitly precluded the availability of foreclosure of the debtor LLC interest or any other remedies that might have thought to have been available at the time. And this was a very welcome change. And I know that there was a significant back and forth between the banking lobby and between the trust lawyers and real estate lawyers lobby to try to get a common ground here. And I guess the compromise was that single-member LLCs aren't protected. And this is explicitly provided for in the statute. So, if you have a single-member LLC or if you have a client that owns 100% of an LLC, there isn't charging order protection with respect to that. And the court could therefore order the foreclosure sale of the debtor's single-member LLC interest and could order the debtor to surrender his entire interest in the LLC over to the creditor. And this is something that needs, we need to pay attention to as advisors, because we want to make sure that our clients are protected. And when they go into entity planning with limited partnerships and LLCs, we want to make sure that they are covered. They do take advantage of this charging order protection. So it's definitely a trap for the unwary. Okay, now we have the question, limited partnership or LLC. Now, a lot of people think, or at least thought, that there wasn't any difference with respect to the charging order protection for these two entities. As the Olmsted case showed us, LLCs were maybe a little less statutorily protected until the Patch Amendment. Now, some commentators believe that limited partnerships are even stronger, even past that, even with the amendment of the LLC charging order statute. And if you look on the second point here, one commentator, who's Tom Wells from down in Miami, in an excellent article presented at a Florida bar conference, indicated that under Florida law, the trustee in bankruptcy, if a member goes bankrupt, could force that member's interest to be bought out for fair market value, unless the articles of incorporation or operating agreement explicitly prohibit such action. And that's just one thing to be conscious of. It's just an interplay of Florida Statute Section 608-4237 and 608-423. We discussed it in detail in our charging order article, which we'll be happy to provide to any of the attendees today if you shoot us an email after this. So basically, to get around this issue, in the LLC's operating agreement, we usually provide that, upon the bankruptcy of a member, that the LLC isn't going to terminate, and under no circumstances will a member be entitled to any redemption of their interest if they withdraw from the LLC, whether it be voluntary or involuntary. And this is just one of those nuanced issues to look at, and it could be a problem if the LLC is established by somebody who doesn't really have much experience with these types of entities, or if office store form operating agreements are used with respect to LLCs. So just something to be on the lookout for. Okay. Ken, you want to talk about charging orders and how they can be more restrictive than originally thought?
Sure. When a charging order is entered by a court, in most situations what you're going to see is the creditors and debtors are going to negotiate, and they're going to come to terms about how they're going to settle the debt that's owed. However, it is a potential that the creditor could actually obtain a charging order and then seek additional action instead of waiting for the potential distribution to come out. As Chris mentioned earlier, this is a remedy that's available for single-member LLCs, in that if they can demonstrate that they're not going to get the distributions within a reasonable amount of time, they can force some other remedies in place. So typically the courts that establish the charging orders, they also have significant discretion with respect to what remedies they want to implement so that the creditor can get his or her funds back. Next couple of slides, what we've done is we've provided some sample language from the charging order. It's a very broadly written charging order from the Colorado District Court, but we thought it was a great example to provide. And basically what it is the charging order requires the partnership to obtain the court approval before doing a wide variety of things. And so additionally, in this case, the creditor was also entitled to get information regarding the assets of the partnership, tax planning regarding its financial information, etc. So it really almost put the creditor in the shoes of a partner, or even in the shoes almost as a general partner because of the court needing the consent. And so basically what we've done here is the sample language that we have is listed here on slide 17 and continues on 18, continues on, actually that was it, 17 and 18. So, but you can see from there that it's pretty good amount of information that's being required by the creditor, or the court's requiring the debtor to give to the creditor. And it certainly restricts the ability of the partnership to actually maintain some of its business the way that you normally would think with privacy and other issues. All right, so turning to tax reporting issues. One thing you have to be aware of is whether a creditor with a charging order is considered the owner of the partnership interest that's held by the debtor. Surprisingly, this still remains basically unclear. You can take the position that the creditor actually would step into the shoes of the debtor, but it can be argued either way. There's one revenue ruling that reached the conclusion that the debtor of a limited partner voluntarily gave the creditor an assignment of his interest, and so therefore everything should be picked up on the creditor's tax return. But again, it's not entirely clear. Chris, do you want to talk about some other common thoughts?
Well, it seems like there's a split here amongst commentators as to whether tax reporting is going to lie with the creditor or lie with the debtor, and it's something to kind of be aware of here. And I guess if you think of it from a policy standpoint, a court's going to be very hard-pressed to allocate any income tax responsibility to a creditor that was allocated income but did not receive the income. So I would be weary of that if we represent clients whose LLCs might be subject, or LLC interests might be subject to charging orders. It's just another one of those nuanced issues here. Okay, now on the next page, we have an exception. Now this is an exception to charging orders in the general sense, in that creditors could or might be able to obtain equitable remedies that we've come across before in different contexts here. And these equitable remedies include reverse veil piercing, constructive trusts, resulting trusts, alter ego, sole purpose theories. And what these essentially do is they, I guess, allow for other remedies when there's fraud involved or there's some type of nefarious behavior involved, and the creditor might be able to reach the actual assets of the entity and to reach the actual management of the entity, which could be essentially deride our charging order protection and what we're really trying to do when we do entity planning here.
Sure. Okay, another potential issue that you could see arising in a lot of practices would be conflict of law issues. There's no guarantee that the law of Florida, let's say you have your client here residing in Florida, but they create an entity in another state. There's no guarantee that the laws are going to be the same between the two states. So there is some question with respect to that, and especially because the uniform acts that we've listed below, they haven't really addressed it. But typically what you'll see is that the courts in these situations most times apply the law of the state where the entity was formed and not necessarily the law of the state of the member or where the creditor resided or even where the claim came from. We really just be the state where the entity was formed is probably your safest bet as to what law is going to apply. All right, Chris, do you want to talk at all about some EMIN issues and executory contracts?
Sure. Now, in the context of bankruptcy law, there's executory contracts and non-executory contracts. An executory contract is a contract where both sides have obligations that have not yet been performed, and in order to receive a benefit, a party must execute these obligations or exercise certain duties. A non-executory contract is a contract where the obligations have already been performed, or one side has already performed its obligations and is merely awaiting compensation or some type of remuneration for its obligation. And in 2007, a case came out called EMIN, a bankruptcy law case, which kind of told us as planners that we should be drafting LLC operating agreements to be executory contracts to impose affirmative obligations on members and partners, impose obligations to comply with fiduciary duties and to be involved in the entity's management. And the reason for this is so that a bankruptcy court would not be able to reach the assets of the LLC based upon Section 365 under the Bankruptcy Code and the executory contract rules. Now, this might be a little beyond the scope of our discussion here, but I did want to make reference to this this case here and how it's affected drafting of LLC and limited partnership operating agreements. And again, we'll be happy to send you our article on charging orders, and we'll be happy to point out exactly where we go into more detail on this issue.
A couple of things that we've added to our forms on the English language, like Chris mentioned, is really increasing the fiduciary duty of the members. Frequently, if you have a manager-managed LLC, or if you have voting and non-voting rights, the non-voting members or the members of the regular LLC don't really have to attend meetings. That's one thing we've changed in our form, is to make it mandatory that they attend the meetings. Another thing that we've also added is we've added a requirement whereby if the company mandates that additional money be contributed, that the members have to contribute that money. Again, just trying to make it so it looks more like an executory contract. Whether it's going to stand up or not, who knows, but at least you're trying to make it look that way.
Right, and then there's the whole issue of the supremacy clause and whether bankruptcy law will actually trump state law so as to disregard charging owner protection. So the idea is if a contract or if an operating agreement is deemed non-executory, it's not going to be binding upon the trustee in bankruptcy, and the trustee can disregard the restrictions in the operating agreement, reach the assets of the LLC or limited partnership. And this goes back to what Ken was saying. If we draft our agreements so that they are more likely to be deemed executory, then the trustee has these obligations that it has to perform, and then you wouldn't have, or you would have a reduced likelihood of a trustee being able to reach the assets in bankruptcy. It's based upon the principles of ipso facto law under bankruptcy law. Any restrictions in the agreement or anything contingent upon a member's interest vanishing or member's bankruptcy or any property being contributed back or being ceded back to the entity upon bankruptcy, that might not stand up under those principles, but we do what we can, and we try at least to put something in the agreements that gives us a better position in the event that we ever face these issues.
All right, now I know one thing that surprised me when we started looking at these rules and everything related to it was the order of priority. Kind of putting on a different hat here, now you would be worried if you were representing a creditor instead of the debtor. You might think that it's actually the order of priority would be based on the order that judgments are entered. However, that's not the case. It's really a first-come, first-served application here. The first creditor that applies for a charging order has the top priority for full satisfaction of his or her judgment. And again, it's not based on the order in which the judgments were actually entered before. It's the order of filing for the actual charging order. And that order of filing has priority over everything else. So if you are representing a creditor, make sure you file for that charging order as soon as you have a potential issue.
Now, Ken, who comes first? A creditor owning a charging order or a creditor owning a secured lien in the assets of the LLC?
At that point, it would still be the secured lien as far as the underlying assets go. And that's just the protection of the UCC, which makes sense in that, that person's already perfected his or her security interest. So they still have priority. But if you're just talking about the outside creditors typically, because most times the outside creditors aren't going to have a security interest in the assets of the LLC.
Right.
So your inside creditors, if they're perfected, are still going to have priority. The outside creditors are the ones that have to fight for the order of filing.
It's interesting to see that the district court got that wrong. The lower court got that wrong. And for those of you who are interested to see their analysis, I encourage you to read that case, Wilson Contractors.
All right. So, Chris, does the LLC have to be the party or the creditor of an eligible owner?
It's not necessary to make the LLC a party to any action to enforce a charging order, because the charging order just gives the creditor the rights of the S&E, which are essentially to receive distributions coming out of the entity. And it deals purely with respect to the debtor member's interest, not with the entity itself. So you don't need to name the LLC if you're a creditor looking to enforce a charging order, but it's probably best to do so just for the sake of making sure everything's covered and trying to avoid any procedural disputes or any little glitches that might come up there.
Okay, a couple other things that you always want to consider when you're dealing with the use of LLCs or partnerships. Number one would be selection of jurisdiction. Again, that gets back to like we were talking about earlier with Florida being the sole exclusive right or remedy being a charging order. It's not going to be the same rule in some other places, so it might be reason not to set up your entity there. Of course, you're going to want to be concerned with the estate tax planning implications. With the Strangey case, being decided, it maybe isn't as bad having the manager being the person you're doing the planning for, but you still might want to split that management up amongst other entities or gift trusts. Another nice thing, too, obviously, with the LLCs is taking advantage of the discounts for lack of control and discounts for lack of marketability. A couple other things, tiered entities, and if you structure these correctly and they withstand audit, they can be a great way of transferring additional wealth because of taking the combined discount on top of a combined discount.
Not even that, just segregating out different asset classes into different LLCs so as to insulate liability, so that any incident on a piece of real estate doesn't leave maybe a bond portfolio that's been paying out distributions at risk. And that's something to think about, certainly.
That's a great point. And Chris, what about the fraudulent transfer statute?
Now, of course, all these charging order laws that we've discussed today are subject to the fraudulent transfer rules under Chapter 726 Florida statutes. So, we have clients or potential clients that would come to us sometimes say, well, you know what, I have a judgment already entered against me. What can I do? Can I do this LLC or limited partnership and get a charging order? I've read about this somewhere. And a lot of times you run the risk of having these arrangements set aside because they're done to defraud, delay, hinder creditors. And it's important to keep these really on the forefront here when you're doing planning for clients, just because we want to make sure that we advise our clients of this potential risk, and we want to know, what might throw, I guess, a thorn in the side or might frustrate our planning here. And fraudulent transfers are certainly one of the ways to get this planning set aside. It's something that would render the asset protection features of charging order planning under entities relatively effectively useless. So it's just something that I can't stress enough. And when we meet with our clients, we want to make sure that we know about timing, because the closer in time between a judgment being entered and the arrangement being set up, the more likely it would be set aside. So it's something that we really need to consider, and again, I just wanted to make sure that we really address this point.
No, I think that's a great point. I mean, with how litigious our society is, you never know when you're going to get sued. It seemingly happens all the time. So if you've done the planning the right way and structured these assets in the right, in an LLC or a partnership to begin with, hopefully that would withstand an attack from a creditor and you wouldn't even need to get into the fraudulent transfer issue.
Right.
So that kind of ties in with our conclusion here that, again, I mean, like all other aspects of estate planning and asset protection, it's really just most important to know what your client's goals are, what their demands are, what their investments are, and keep up with them so that you can help them structure everything in the right way, a way that would be most protected rather than leaving it exposed unnecessarily.
Well, thank you very much, Ken, and we appreciate the attendees for attending today. And as we've said, if you would like a copy of our charging order article, please feel free to email us. Our email address should be on the front page of the website here, and we'll be happy to send you a copy of it. And again, thank you very much for joining, and we appreciate your support.